Hello and welcome back. We're moving on now to look at how we create our company, and there's two ways that we need to consider. One of them is to buy an off-the-shelf, a ready-made company if you like, and the other one is to set up our own company. The second one's probably most common now because it's so easy to set up a company using the Companies House website. However, if you wanted to buy a ready-made company, you can do so. This is effectively a shell of a company that's been set up by someone else on your behalf, a company formation agent. And they'll set up any number of companies, each with probably just a silly name or a number for identification purposes, but those companies won't actually have anything going on in them. The shareholders of the company will usually be the names of the directors of the formation company, and one of those people will also be named as a director of this shell company. Now, it's usually more expensive to buy an off-the-shelf company because it's already set up by someone else. Someone has done the work and they'll expect to make a profit out of that. So why would you do it? Well, it is a little bit quicker than setting up your company yourself because it's ready to go. You can start trading instantly. It also helps with a problem that we're going to look at later on, which is pre-incorporation contracts, because your shell company, even though you may not have owned it in the last week or yesterday, actually probably still existed, which means that it can help with contracts that you enter into before you've actually bought your company. And we'll look at that in a moment. Disadvantages, they're not really disadvantages, but there are factors to take into account when you buy an off-the-shelf company. It's probably got a really silly name, like Company 1234 Limited. You're probably going to want to change that. You don't have to, but you might want to. What you will have to do is transfer the subscriber's shares into your name, because those subscriber shares will be owned by the company formation agent, and obviously when you buy the company you need to take over those shares. The directors and probably the company secretary are also going to be the company formation agent, so you're going to want to change that as well. And then you may decide to change the company's articles. You don't have to do that, and the company will almost definitely have the standard articles. If the standard articles are good for you, you might leave those alone. Okay, so that's an off-the-shelf company. Most people will actually form their own company. Now, to do this, you pretty much complete some of the forms online, and you must send a number of documents to the company registrar. Now, those documents, we come down to the mnemonic MASOC, and we'll look at those in a second. They're over the page. You send those documents to the company registrar. He will register the company and he'll send back a certificate of incorporation. This is a really important document. This has the date the company was incorporated, the details about the company, and also its registered number. Now, as we'll see later, you can change the name of the company. You could change the status of a company from limited to unlimited. You could go from a limited company to a PLC. But your registered number will never ever change. That number stays the same no matter what happens to the company. Now, once you've got that certificate of incorporation, if you're a limited company, that's it, you can start to trade. But if you are a PLC, you're also going to need to get a trading certificate before you can start trading. Remember the Section 761 certificate we mentioned earlier. So how do you get that certificate? Well, let's have a quick look. You send your application to the company registrar saying that your nominal value of your shares is not less than the authorised minimum, and you send a statement of compliance saying that you've complied with the requirements of Section 761. That's just a piece of paper that's signed by the subscribers. And once you send that document, you get your 761 certificate back. Then you are able to start trading. If you don't remember, then the company officer in default, so probably the director, might find that he's liable to a fine. And also, remember that point we mentioned about the corporate veil, he's potentially liable for the debt of the company. Note though that the transactions the company's entered into, they're still valid, they're still enforceable. If you don't get your trading certificate within a year, then that's an excuse for the company registrar to compulsorily wind up the company. So effectively tidy up the registrar, get rid of those companies that aren't able to trade. So what are we going to send to the company registrar? Well, here we go. Again, you need to learn this list. I know it's dull. Get someone to test you on it. Make sure you can write it out. And remember, it's MASOC. So, what do you send? First of all, the Memorandum of Association. This is just a prescribed form. You can print it off the Companies House website. And it says that the subscribers are the first shareholders. Okay, the people who are setting up the company, who get the very initial shares that are issued. So the subscribers want to form a company and they agree to become shareholders in that company. And they're going to have 1 share each. Each subscriber must sign it. Okay, so it's a fairly formal document. It used to be a much more interesting document, but since the new Companies Act has come into force, it's much simpler. And then they send an application. This has got a lot of the important information in there. The company's proposed name. We'll look at names later. Whether it's going to be a limited company, and if so, shares or guarantee. Public or private. And then this one always winds me up. Whether the registered office is in England and Wales, or Scotland and Northern Ireland. And this is the bit that winds me up. Why does Wales happen twice? Also, that's just the sort of jurisdiction of the company. The other thing you need to say is the address of the company. Now, this is the registered office. This is an address for service. So whatever the registered office is, any document or legal document that's sent to that address is deemed to have been served on the company. So you're deemed to have had notice of it. So you send that application with those details. And then we have a series of statements. There are 4 statements. A statement of capital and initial shareholdings. Now, this is basically a document that says everything there is to know about the company's share capital at the date of incorporation. Now, you might change your share capital the following day, doesn't matter, it's just at that first date. How many shares have you issued? What classes of shares have you issued? What is the nominal value of those shares? Remember the face value. What are the rights attaching to those classes of shares, and how much has been paid on those shares and how much is still outstanding. Key information about your share capital. Now, obviously, if you are a company limited by guarantee, you won't have share capital, so you will send instead a statement of guarantee. A statement of guarantee literally just says how much do the guarantors agree to contribute to the company if it's wound up. You also need a statement of proposed officers. Who are the officers of the company? The directors and the company secretary. And finally, a statement of compliance. This is just a piece of paper in a set form. It says that the shareholders confirm that the requirements of the Companies Act have been complied with. And again, it's signed by all the subscribers to the company. So it's just a very routine document. As I say, remember, try and learn that list. Of course, you'd also send a fee to Companies House. Now, this is something I mentioned earlier, pre-incorporation contracts. Imagine you are setting up your new business. You're really excited about this business. You're getting everything ready. You find a suitable building. It's going to be a shop. You want to rent the shop. However, you've sent your documents off to Companies House, but your company hasn't yet been formed. You haven't yet received the certificate of incorporation. Now, the temptation is that you will want to sign that lease for that shop before the certificate of incorporation is back. That, if you try to do that, would be a pre-incorporation contract. You are signing a legal contract in the name of the company before it exists. And the law has very strict rules about how those contracts are going to be enforced. Now, when you start to do that, when you start to make steps to set up your business, you are what we call a promoter. And there's a definition there. Promoter is the person who makes business preparations for the company. Now, this is not the person, as it says there, who takes procedural steps. We're not talking about the solicitor or the accountant or the company formation agent who might be helping you. None of those. The promoter is the person doing sort of the commercial stuff, if you like. Now, as a promoter, you owe special duties to the company. And there's 2 of those. The first one is a duty to exercise reasonable care and skill. And that duty will really depend on how skilled you are. But there is a de minimis there that you're expected to uphold, a bit like a director's duty, as we'll see later. The second duty is something called a fiduciary duty. Now, we will see this term quite a lot in the coming chapters. Fiduciary duty is a duty of good faith, and it arises where you have one person in a position of trust, particularly where we have a financial relationship. So if you learn a fiduciary duty as a duty of good faith, that should get you through most questions. So a fiduciary duty is a duty of good faith. That means if you've got a personal interest in a proposed transaction, you're going to have to do something about it. Now, that usually means you just have to disclose your interest so that the other investors in the company know that you've got a vested interest here. If you disclose your interest, then that usually means that if you do make a profit, you can keep that profit. But if you don't disclose your interest, it's what we call a secret profit. And a secret profit means that when you're found out, you must account for that profit to the company. However, by disclosing the profit, that legitimizes the profits and you should be protected. Now, who you disclose to is difficult. If it's a PLC, your disclosure is going to be in the listing document, in the company prospectus. But if you're a private company, then officially the rule is to an independent board of directors, but the chances are you're going to be one of those directors, so you disclose to the prospective shareholders and to the company board of directors. Now, if I give you an example, perhaps just to make that a bit more real, imagine you've owned a piece of land for years and years and years, and finally the planning rules change. That land can now be built on, but you don't have the money to build on that land. So you decide to set up a company, to incorporate a business, sell your piece of land to it, and get some investors to help you develop it. Now, when you set up that company, you are the promoter. You owe a duty of reasonable skill and care, and also the fiduciary duty to the people who invest in that company that you've set up. So you need to tell them that the piece of land this company is going to develop is owned by you. You need to tell them how much you paid for that piece of land originally and how much profit you intend to make when you sell it to the company. Now, provided you do that and they understand and accept that profit, then that will become a legitimate profit which you can retain. If you try to hide that fact, it becomes a secret profit, and when the rest of the company investors find out about it, you could be asked to account for your secret profit and transfer the money to the company. You may also find that the sale agreement you had with the company might not be enforced. It might be set aside because you didn't make that disclosure up front. Okay, so returning now to pre-incorporation contracts. You're setting up your business and you want to enter into a contract before you've got the certificate of incorporation back. Now, the court says the pre-incorporation contract, it's a bit like an agency arrangement if you think about it. You have the promoter who negotiates a contract with a third party, and his hope is that that contract will be on behalf of the company. However, the law says because the company doesn't yet exist, it has no capacity to enter into a contract. Therefore, there can't be an agency relationship. So, we haven't entered into a contract on behalf of the company. Could the company ratify the contract? Could it adopt the contract after it's received its certificate of incorporation? Well, the answer is no, because if you think back to authority and ratification of contracts, you can only ratify a contract if the principle existed when the contract was made. Well, this company wasn't set up, therefore it didn't exist, it had no certificate of incorporation. And that's the point I was making earlier, where an off-the-shelf company might help, because your off-the-shelf company was probably literally sitting on the shelf of the formation agents when that promoter made the contract. Therefore, it would be able to ratify the contract. Now, as the company has no capacity to enter into the contract, as it can't ratify the contract in most cases, that means that the company is going to have no rights under the contract. It can't enforce them. And similarly, the law says, well, if the company can't enforce the contract, who can? This guy can, the promoter. The promoter has a contract with the third party, and the promoter and the third party can enforce that contract against each other. Now, one way around that would be if the promoter and the third party had entered into this contract and they'd used the powers of the Contracts Rights of Third Parties Act. Because you'll remember that that act gets around some privity of contract details. That says that if you name the company in your contract, you make it clear that the company should have the right to enforce the contract, then that would give the company rights under the contract, which is a good thing. And remember, the Contracts Rights of Third Parties Act applies even to entities that don't yet exist at the date of the contract. So that would seem to solve your problem, wouldn't it? We now would have a contract that the company has a right to enforce against a third party. However, just one word of caution there, because if you do go this route, the promoter also is still liable under the contract. Although we've given the company rights to enforce the contract, what we haven't done is absolve the promoter from any liability under the contract. So the third party here is sitting quite pretty because he can now choose. He can enforce his contract against the promoter or against the company. If you want to avoid this problem, what should you do? Well, the simple answer is wait. You've found your dream shop, you're all ready to go. You say to the landlord, right, I'm just waiting for the certificate of incorporation to come back. Can we draw up the documentation and we'll be able to sign it as soon as we have our certificate of incorporation? That's the cheapest, simplest way. Using an off-the-shelf company, we've just talked about, that gets around the ratification problem. Or we could do something called novation. Now, this is a legal term, and what novation means is that we enter into a contract with the landlord, and that contract will be between the between the promoter and the landlord. But that contract will have a provision in there that says as soon as the company is incorporated, we will enter into a second contract which novates the old one. And what that means is it cancels the old contract and replaces it with a new contract between the company and the landlord. And in that case, we have novated the situation. We're in a position as if we'd done it right in the first place. Now, the problem with that is that obviously there's a lot more legal fees involved, a lot more drafting. So unless it's something really, really important, you probably wouldn't want to go there. Now, final point about promoters, which is this point about expenses. As the person setting up the company, you are bound to incur some expenses, some legal fees maybe you've got a solicitor to draw up articles, maybe you've had some valuations carried out. All these expenses you might want to recover from the company once it's up and running. Now, there is no legal right to do so. However, in practice, most occasions, the promoter will agree with the first company's directors that he should be reimbursed for those expenses, and there's no problem with the directors agreeing to do that. Now, here's another question. As always, pause the recording, have a go at it, and then we can compare our answers. Okay, so this is Imran. He's setting up a new company. That makes him the promoter. And before he submits his application for registration, he enters into a contract on behalf of the company with Greenfields plc. So we know that this is a pre-incorporation contract, the company doesn't yet exist, and we know that although he purports to enter into this contract on behalf of the company, that's not the case. It's really a contract between Imran and Greenfields. Shortly after the company's registered, a certificate of incorporation is issued. Silver Stumps finds that it hasn't got enough money to purchase the land. So what have we got? We've got Imran, who's negotiating a contract with Silver Stumps, and the company is called Greenfields plc. So he'd really like the contract to be with Greenfields. We know that there can be no contract here between Silver Stumps and Greenfields because Greenfields doesn't exist. So let's have a look at the requirements. Greenfields may enforce the contract against Silver Stumps Limited because Silver Stumps automatically assumes responsibilities for contracts entered into on its behalf. That is rubbish, isn't it? Number B, provided Silver Stumps ratifies the contract, Greenfields may enforce the contract against Silver Stumps. Well, that's wrong because Greenfields will not be able to ratify. It didn't exist when the contract was entered into. Greenfields may enforce the contract against Imran personally because Silver Stumps cannot ratify the contract. That sounds quite likely, but check Part D as well. Imran's liability on the contract ceased because he has transferred all rights to Silver Stumps Limited in accordance with the Contracts Rights of Third Parties Act. Well, that one you might hesitate over, but there's no mention of the Contracts Rights of Third Parties Act, and remember, for this to apply, the contract would have to make it clear. Even if this Rights of Third Parties Act did apply, it doesn't absolve Imran from liability under the contract. He will still be liable. So the answer there was C. Now, final thing I want to cover in this lecture is the company's names. Now, basically, you can choose any name you like for your company, so long as it isn't already being used. And you can search online against the company's registrar's index of names to see if the name is already being used. If you're a public company, we know you have to have PLC. Private company, you need limited or LTD, or the Welsh equivalent. Then there's a few other names. First of all, you can't have a name which the company registrar says is offensive. So you couldn't have a name that maybe, I don't know, Fatties Are Us, or a name that was racist or otherwise offensive. That won't be allowed. There are also some names that the Secretary of State say are sensitive. So a name that suggests you're connected with the government or with local authority. Also, there are names which require approval. For instance, if they suggest a connection with a religious body, if they suggest size, so the words British or international aren't allowed. You're not allowed to use the word group unless you really are a group of companies. And you'd have to prove officially to the Secretary of State, but certainly to the company registrar, that you meet those requirements before you use those words British, international, group. And your name, as we've already said, can't be the same or virtually the same as an existing company. Now, if you want to change your company name, you can do that. That's fine. That is like fairly significant change to the company's makeup. So you would need a special resolution. That's 75% of your shareholders would need to agree, unless the articles say otherwise. Now, when you change your company name, you file a copy of that resolution with Companies House. The company registrar will issue a new certificate of incorporation. Remember, you'll keep the same registered number, but it will have the new company's name on it. Now, occasionally, you may have to change your company's name, not because you want to, but because the Secretary of State tells you to. And that will be if it transpires that you've got the same name as another company, or a name that's very close to another company, or a name that the Secretary of State thinks might mislead the public. Just a few rules about your name. You must disclose your company name in certain locations. That's basically outside your place of business, on your key documentation, and also if you have a company seal, then you must have your name on there as well. I'm not sure how many companies still have a seal. Now, some businesses don't trade under their company name. It's unusual for a company because usually you would choose a company name that suited your business, but you can adopt a business name. So I could be First Intuition Limited, trading as Law Courses. That would be my business name, Law Courses. Now, if that's the case, I'm subject to all the same rules about prohibited names and consent of the Secretary of State, and I'm also subject to rules about disclosing my business name as well as my registered company name, so just be aware of that. Now, before we end this recording, have a go at question 12, formation of a company. What documents must you submit? Remember, MASOC might help you here. There you go, there's my list. The Memorandum of Association, the application, the Statement of Capital. I've put the Statement of Guarantee there, but only so that I can cross it out, because that is not relevant here, is it? This is a private company limited by shares. I wouldn't need the guarantee. Statement of Offices and a Statement of Compliance. Now, just a word of warning there, that the examiner will sometimes try to make you think that a company must submit its Articles of Association when it is formed. Now, you don't have to do that, because in most cases a company will be formed relying on the standard articles of association. So if you don't submit any articles, it's the standard articles which will be deemed to apply. You only need to submit articles of association if you want to deviate from that standard articles. And we're going to look at articles in the next lecture, so I'll leave this one here, mainly because I've said articles too many times in one sentence. So I'll see you soon for the next lecture.